there being a juror communicating with somebody on the Law and Crime live stream who chatted that they were in communication with the juror and suspiciously was able to say before it was published that they were going to go with the third count, which was third on the verdict form, specifically saying attempted manslaughter due to EMED. Can you break down the rules of communication and if that is means for a new trial?
Sure. So juror misconduct is a thing, and there's a lot of case law about juror misconduct. Juror misconduct interferes with the constitutional right to a fair trial. And I would think that a trial judge is going to take that extraordinarily seriously and has that duty to investigate to see what impact that had on the jury's impartiality.
Welcome to the podcast. We have a very special guest, attorney Benjamin Lowenthal, who is a federal, state, and experienced attorney of over 20 years. And although he doesn't like to mention it, he was a finalist for Chief Justice of the Hawaii Supreme Court. Welcome to the podcast, attorney Benjamin Lowenthal. How's it going?
Great. It's doing great. Hi.
The first question that I wanted to talk about with State versus Konig is there's all this controversy over the verdict. Is there something that sticks out in your mind as either cause for a new trial or cause for an appeal?
Well, as an attorney, I got to say it. I was not part of the defense team. I was not part of any part of this case. I was just observing it just like you and me. I know you've observed it with far more scrutiny than I did. But based on what people are asking me about, when I see them in the street, I would say that the verdict of extreme mental or emotional disturbance, EMED, has got everybody talking. And I would say this, that if there is a vehicle, that's a term we use in appellate law, if this case stands as a vehicle for the Hawaii Supreme Court to reconsider a decision not too long ago, it was the case is Adviento. This case is an opportunity, if the Hawaii Supreme Court wants to, an opportunity to reconsider the rule in Adviento. And that is the rule that requires the trial judge to instruct the jury about EMED, whether the defense wants it or not. I think that's kind of the case. This is a very good case to rethink that rule.
I thought it was so funny because attorneys like yourself and, some of the top guys, they've randomly called me because I'm so deep on this case. And one of the funny comments that I've heard time and time again is, Tommy, one of the best to ever do it, was arguing self-defense. And then the prosecutor was arguing like a premeditated murder in the second degree. Neither of those arguments were actually like fully embraced by the jury. And then they split the baby, so to speak, and say manslaughter, not murder, manslaughter due to emotional distress, which the defense did not want in there and wasn't centering their defense on.
Our position is EMED should not be given, and we're telling the jury it did not apply. And when he said that, I was in a severe emotional state, he was talking about after the fact, not when he did what he did. I asked him, how did you feel immediately after this? He said, I was in a severe emotional state. So that, if he's suggesting that he said that to try and get convicted of EMED, that's ridiculous. Because number one, we're saying EMED should not be given. We're telling the jury that it should be disregarded. And number three, the comments he made about being in that state was after the fact. Obviously, for EMED to apply, you have to be in that state during the incident.
So I guess the follow-up question would be, what's the legal standard when you have a defense making one argument, self-defense, and then you have the prosecutor making a completely different, argument? What's the standard for the EMED to be stuck in there?
Well, it's a scintilla of evidence is the phrase we like to use. A scintilla of evidence is like real small. If there's anything in the record that was presented in front of the jury, and it's got to be admissible evidence, that suggests a defense, like self-defense, then the judge must instruct the jury, and this is all Hawaii law, must instruct the jury about that defense. So if the defense is self-defense, and there is something, no matter how weak, a scintilla of evidence to suggest that it was in self-defense, the defense gets that instruction. What makes this a little different is a couple things. First of all, EMED is an affirmative defense, which we can talk about a little later. An affirmative defense means the burden is on the defense to prove that this defense occurred, as opposed to the government disproving the existence of the defense. So it's an affirmative defense. And this case, Adviento from 2014, says, if the record shows a scintilla or shows some evidence of EMED, then the judge must instruct, regardless of whether the defendant wants that defense or not. And so that's what makes this case a good vehicle for it, because the defense was pretty clear. Didn't want that defense. It was going for self-defense, and the result of a self-defense verdict is not guilty. What makes EMED less attractive for a lot of defendants is that it is an incomplete defense, so that if the jury were to agree that this was a product of an extreme mental or emotional disturbance, the legal result is not an acquittal. The legal result is manslaughter, which is what we have here.
Yeah, it is kind of like a high risk, high reward, but I think it's worth going for, because why not try to get the full acquittal, especially if you're a doctor with a license to renew, and you could theoretically start your life again after some time. This is going to be devastating for Dr. Gerhardt Konig. If he was to actually win, he'd have a path to starting his new life if he didn't have the conviction. So I think it's the right move, especially.
I'll jump in. One of the things I do when I counsel my clients is we spend a very long time talking about the goal. What is the goal? We don't necessarily want to, although it's very tempting to get caught up in the drama of trial court, or sometimes getting caught up in the legal snit that people find themselves in. And so I like to step back and say, what's the goal here? And I am confident that Dr. Konig and his defense team have had many discussions about what the goal is. Because once you establish the goal with your client, which has nothing to do with the case necessarily, that allows you to create the path and to deal with the realities of things. People have all kinds of goals. And I know it may sound silly, but like for a lot of people in a criminal defense case, the goal is, I don't want to go to jail. Or the goal is, I don't want a conviction. And so then it gets harder to start saying, well, okay, if the goal is no jail, can you live with a felony conviction and no jail? Can you live with probation and no jail? Sometimes the answer is no. It's just, that is why we have attorneys. That is why clients and attorneys have to sit down and talk about their goals. As a commentator here, I can't really get into that. I can only tell you about the legal landscape that Dr. Konig is facing. But for whatever reason, a decision was made not to go for EMED. Okay. Unfortunately, that decision is not up to the defendant. That decision is for the trial court to assess the evidence and give the jury the instruction. Now, Adviento is interesting because that case that stands for that proposition has a bunch of reasons why it's with the trial judge. And if you actually go back and look at the facts of Adviento, they went so far as to go on record and say, Judge, we don't want EMED. I'm waiving the right to present this defense because it's my case. And the trial judge said, great, and did a question and answer on the record with the defendant, waives this right. Hawaii Supreme Court says that you can't do that. And they said you can't do that because there's this phrase that keeps popping up in Hawaii case law. Our trial courts aren't gambling halls. And the verdict is supposed to represent a true result of what happened without getting too far down. Verdict has a Latin root, veritas, for truth. And so this competing principle of the defendant's right to present what defense they want and their goal is in conflict with this other competing principle of the trial judge's obligation to instruct the jury about all possible defenses and results. And the Hawaii Supreme Court made that call in Adviento that that principle trumps clients' goals sometimes.
Damn, Ben's out here cooking, right? Anyway, this is the only YouTube station you're going to get this level of analysis from this qualified of a practicing attorney. So go ahead and subscribe so you don't miss anything upcoming. And I'm sure Judge Wong probably reread that. And I know I'm putting you on the spot, but did you happen to reread Walsh? They did mention that the defendant introducing or steering the verdict towards emotional distress.
I did not, I'm sorry.
Okay, no worries. Because they had like a little clip where
comments he made about being in that state was after the fact. Obviously, for EMED to apply, you have to be in that state during the incident. So,
And that's the only tailoring argument that you're considering, Mr. Garner?
Like you say, make it sound like I should be considering more, but that's the only one on my mind at the moment.
I'm not suggesting you should be considering more, but because my general inclination is to keep it out at this point in time. And so I wanted to know if you had more, because I will go back in and I will reread Walsh.
Yeah, I was like, what's the fuck is Walsh?
Well, Walsh, if I remember correctly, Walsh is the one where it prohibits prosecutors from arguing to the jury that you shouldn't believe the defendant because they were there to sit there throughout the whole trial and shape their testimony.
Yeah.
Yeah.
And he might have been shaping the testimony towards emotional distress, which I'm sure Tommy went over and was like, yo, don't.
Well, that I cannot comment on because who knows? Yeah, the principle in Walsh is a little different, is that the prosecutor can't just get up there and say, of course, the defendant's testimony is so good because they got to sit there and listen to every single witness.
Yeah.
See that? The reason why that's a problem is because the defendant has not only the right, but a requirement, unless the judge orders otherwise, to sit there, to sit through that trial. And we are the courts are jealously protect this idea that prosecutors cannot exploit the exercising of a constitutional right. They can't get up there and say, well, the defendant didn't talk to the police. He must be hiding something because you have a right not to talk to the police. So it's the same concept, right? They can't get up there and say, well, of course his testimony is great because he sat there and got to listen to every single witness before he testified. Nope. That is exploiting the right to be present at your trial.
Yeah, and there's an element of tailoring your testimony if you're last towards the end of the actual trial, right? Because you got to sit through everything.
The accusation of tailoring becomes a problem, and that's what Walsh discusses. And it's building off of a United States Supreme Court case. So it is the law of the land everywhere.
Nice. Did you get a chance to review the verdict form?
I did. Yes.
All right. So from another podcast, which we'll put a link in the description, one attorney had a problem with the form of the verdict form and the split between the verdict form and the special interrogatory. So for our listeners, can you explain what a verdict form is and how it differs from the special interrogatory?
A verdict form is the roadmap for the jury. So jurors don't just sit around in the deliberation room and decide whether they like the defendant or not. They're given a lot of instructions about what the law is, And there are some key instructions. And one of the key instructions that they get are the elements of the offense. You can't, a classic example would be like assault. They have to prove, the government needs to prove beyond a reasonable doubt that the defendant, caused bodily injury and that the defendant did so knowingly or intentionally. And that as a result of that, the defendant or the person suffered a certain level of harm. I mean, I'm just making that up, for example. Those are what we call the elements of an offense. But there's no place for the jurors to do anything. The only place where the juries communicate and how the juries communicate with the judge is with the verdict form. And it's really just a bunch of lines to either check or mark in a criminal case. So in a civil case, it's a little different, right? In a civil case, they ask a series of questions. Do you find the defendant liable? If so, what percentage of liability sometimes? How much damages are you going to award? And they actually have to write in the number in some cases. That's not the case with a criminal case. They simply check one. In this case, they had a bunch of options. Do they find the defendant not guilty? Do they find the defendant guilty as charged of attempted murder in the second degree? And then from there are these other offenses. You have what they call included offenses or lesser included offenses, assault in the first degree, assault in the second, and assault in the third. And you have the incomplete defense of attempted manslaughter based upon extreme mental or emotional disturbance. So a lot of the issues that may arise, or that defense attorneys like to point out, is where do you put these offenses? In what order are you going to be putting these offenses? And, there's a lot of back and forth about that. The judge ultimately decides that. Now, once the jury's done its job in picking one, depending on which one they pick, they may have to move on to a special interrogatory. In this case, they did have a special interrogatory, which says, if you find the defendant guilty of assault in the third degree, you got to answer this question. And then they have a special question, right? And the assault third question was, was this the result of a fight or scuffle that was not entered by mutual consent? The answer to that question is going to affect the applicable sentencing options for the judge. And so that's basically how it works. And in this case, the verdict form was just something to check. The instructions explain how to go, where, and when.
All right, quick side quest. Here are the jury instructions, and I just wanted to point out that the jury instructions are 44 pages long. So it's very complex, it's very long, and I do sympathize with the jury because during the multi-week trial, the defense nor the prosecution argued EMED. This was something that was put into the jury instructions because of the scintilla rule, and it wasn't argued and gone over at length like how all the other charges were. So I sympathize with the jury because it's very difficult to be given a 44-page document that says, hey, go ahead and figure this out. This guy's life is on the line. You could put him in jail for the rest of his life with the possibility of parole. You could put him in jail for 20 years, or you could acquit the guy. So that's a lot to put on a jury. And I do believe that putting the EMED option that wasn't argued throughout the multi-week trial all the way at the end, and only reading the jury instructions out loud once, then just handing them a pamphlet saying, here's 44 pages worth of instructions, now you go figure it out. I think that's a lot for any jury to handle.
And so sometimes, mostly in civil cases, verdict forms will actually put it in the verdict form itself. If you find the defendant not guilty of count one, you must then move on to consider the included offense of X. And they actually have that written in the verdict form. And so it kind of acts as a roadmap. It's not in this verdict form, so I can only assume it's in the jury instructions.
Yeah, it was in the jury instructions, but those instructions were very complicated. And then to add towards the end of the trial, because of the scintilla rule, the EMED option, that was a lot for a common juror, a common jury to like go ahead and comprehend. And I think, of course, not an attorney, but I'm just a guy who looks at documents all day. If they would have split up the verdict form and the special interrogatory differently and instead put the EMED part in the special interrogatory, it would have been far more clear by virtue of having to first select attempted murder in the second degree, and then the special interrogatory would have those that language that you're talking about specific to EMED, then they could check that instead of having the mutual affray. I think this could have been all avoided.
I see what you're saying. I think I see what you're saying. If I could just repeat it back to you so I understand it. You're saying, well, EMED is an incomplete defense. It is not an included offense like the assaults. Therefore, you can't answer the question of EMED until every element of attempted murder is found. Now, you could break it down that way, I guess, without looking at the case law. Big caveat there. But I think what you're saying is, would it be cleaner to have the option of if and only if you find the defendant guilty as charged, you can then go on to answer this question of EMED?
Yes.
Now, it's interesting because the standard jury instructions in Hawaii for EMED take pains to avoid the G word, guilty. The instruction on the pattern instructions say, if you find every element of murder or attempted murder proven beyond a reasonable doubt, you must then answer this. You must then move on to determine whether there's EMED. So they don't really want to say guilty of murder. I can only assume it's because of double jeopardy purposes. Is it an acquittal of murder when they come back with an EMED verdict? You know, that's going to be a big question here, right? So perhaps there are benefits to not ascribing the label of guilty of murder with an EMED verdict nevertheless.
Yeah, that the ambiguity cuts both ways because it's really up to the attorney to make the argument that the court will go for, right? Sometimes that ambiguity might be to his advantage if the defense is persuasive enough. I don't know if they're going to go that direction, right? The motion for the new verdict had quite a few, well, it had 3 different arguments. I write in my newsletter a breakdown of the 3, and we've done videos on that, so I'll go ahead and put that into the description. And viewers, we are very open to questions, so comment questions. This is an ongoing thing, and we could always get your questions answered. But I felt as though from the new trial motion, the third argument was probably the strongest, there being a juror communicating with somebody on the Law and Crime live stream who chatted that they were in communication with the juror and suspiciously was able to say before it was published that they were going to go with the third count, which was third on the verdict form, specifically saying attempted manslaughter due to EMED. Can you break down the rules of communication and if that is means for a new trial?
Sure. So I haven't looked at the motion for new trial. I've only talked about it with you. But juror misconduct is a thing. And there's a lot of case law about juror misconduct. Juror misconduct interferes with the constitutional right to a fair trial. There's a case back in 1991 where a juror brought a dictionary into the deliberation room. Misconduct.
A dictionary.
Yes.
What if they were just trying to like define and this is also funny. It shows, yes, millennials, Gen Alpha, Gen Z, at one time you'd have to actually look in a book and define things in alphabet. You'd have to find a word in alphabetical order. That might be a new concept for a lot of people. There's such thing as a dictionary that's not digital.
Well, so claims of jury misconduct can arise to a violation of the right to a fair trial. We have all kinds of specialized terms and language when we deal with this, but the basic concept, I think, for the everyday person is, look, misconduct happens a lot. Is this the sort of misconduct that we call substantially prejudices the right or the trial itself? And once the defendant raises a claim of juror misconduct that deprives the right to a fair trial, the trial judge has a duty to investigate. And so they can look at evidence, they can make a determination based on what we call a totality of the circumstances, which is a nice phrase of saying everything that they have in front of them, to determine what impact the alleged misconduct had on the jury's ability to be impartial. So this issue of, well, a juror was in contact with a member of the press, they're supposed to be sequestered. The sequester rule is important because it preserves the integrity of a fair proceeding. And I would think that a trial judge is going to take that extraordinarily seriously and has that duty to investigate to see what impact that had on the jury's impartiality. This gets us into other discussions about a presumption that it was prejudicial, and when the presumption applies, when it doesn't apply, there's all kinds of debate and sparring and case law about that too.
So we're probably going to see before sentencing a motion in opposition to a new trial. Is that
a memo in opposition, right? So you file the motion. A motion is just a request to do something. In this case, it's a request for a new trial. The prosecutor is going to file a memorandum in opposition. They're not requesting anything. They're saying deny that motion. So I do mean to be technical. That's what I do, right?
Yeah, you're the appeals guy. You got to be technical. Thank you for adding that.
Sure.
So at a later time, it'll be interesting to read Mr. Gardner's memo of opposition so that we could see exactly how, I guess, he makes the argument that the suspected, and it's what his office disclosed. They came across the information and disclosed it. Exactly how prejudicial or not, obviously he's going to say it's not prejudicial because why not take the win, right?
Well, let me stop you right there because I think this is important. This is our system at its best. A prosecutor's job is to do more than just win. It's to seek justice. And if the prosecutor came on to something like this, the fact that they disclosed it, is our system working? Whether it's prejudicial or not, whether it warrants a new trial, whether they have to do it all over again, that doesn't matter, because if it does raise this specter of an unfair proceeding, it doesn't matter who finds out. And the fact that the prosecutor brought this up should be something that we as citizens and people here should be happy to see. So I just want to put that out there.
We will give flowers to Mr. Gardner, who was looking in the interest of justice. And for a younger up-and-coming prosecutor to go up against the boogeyman, Thomas Otake, I wrote in my newsletter, I was like very impressed by his resilience, because I don't know if this is transmitted on the live stream, but when you're there live, Tommy is a domineering person. He does these long pauses. He glances over, he says these things, and he goes back to the judge. He objects vigorously over everything. And I was like, man, that's got to wear on you, especially when you're young and up and coming and going up against the GOAT.
Well, Tommy's definitely one of the best. And I've never worked with Mr. Gardner, but I've seen him around. And You know, we're all colleagues on the same bar, and it's hard. Sometimes it's easy to forget that, but at the end of the day, we're all members of the same profession, and so
Yeah,
just
no. And he's able to turn it on and off, and then he's normal again. Like he's normal again. I was like, wow, you were seething and glancing and like, and then you could feel it in the room. And then the moment it's off, it's like, okay, yeah. And then he's talking about, oh yeah, so what's the schedule for next? Like he just casually goes on. So props to be able to weather that storm from Mr. Gardner. Oh my.
there's a I saw a meme. It's that picture of, I think, that actor Timothy Chalamet sitting courtside at the Lakers game with the two women. One's all done up and he's chilling, and then there's like the intense one with the glasses. So someone made one where it shows Chalamet lounging and it says trial lawyers, and then it showed the woman with the glasses looking intense, right? Appellate attorney. And then the one that was all done up was in-house counsel.
Yeah.
So
That's good.
anyway, you should try to find out. That says it all.
This is an interesting thought experiment. A lot of speculation here, but just a thought experiment. If the jury did not convict of attempted murder in the second degree, does that mean upon a new trial, double jeopardy applies and the prosecution could not try to recharge that top most serious offense?
That is the big question. And I think this kind of gets back to the issue you have about the verdict form, right? The beginning of your question really says it all. If they did not convict, well, the answer is they did not. If you look at the verdict form, they didn't convict. It's crystal clear they didn't convict of attempted murder in the second degree. They came back with manslaughter. And so in a lot of ways, this verdict form that people are chirping about, in some respects, is unclear. In a lot of other respects, when it comes to double jeopardy, the argument can be made that it is crystal clear. There was no conviction of attempted murder in the second degree. Therefore, if you win on anything on appeal, and you being the defense, the remand and new trial should only be limited to attempted manslaughter. Now, a lot of lawyers ask me, how does that work? How do you do this? And you know, there's an old case. I should call it timeout. I haven't had a chance to check this yet, so I will say this today, and I want to confirm later. And if we have to rebroadcast just so I can correct, I will. There's an old case that really kind of talks a little bit about what you're supposed to do in this situation on a remand. If the appellate court comes back and says, for any reason, let's say a piece of evidence was used that shouldn't have been used, and it gets remanded and sent back for a new trial, double jeopardy would suggest that you could do the trial, allege attempted murder in the second degree, and if the jury comes back, if the second jury comes back and says, yes, this was attempted murder in the second degree, the judge cannot sentence Dr. Konig to life. The judge's sentence is limited to whatever it is that was originally found, which would be the 20 years. So it's inartful, but that's at least one case that attempts to resolve this problem. This is a very interesting case. It's called Whitting. It is from 1998. Let me just read it because I think it's worth it. We might, oh yeah. You should read it too, Nick. Let me just read you. This is why I love the law. Okay.
Are we breaking? Are we breaking?
This is a break. This is a break. Whitting was indicted for allegedly causing his wife's death. He was convicted of manslaughter due to EMED. On appeal of the jury's verdict, the ICA vacated the conviction, remanded the case for a new trial because the circuit court failed to question jurors about a potentially prejudicial pretrial publicity. On remand, Whitting moved to dismiss on the grounds that a retrial violated double jeopardy. The motion was denied. he appealed the motion to dismiss. The court dismissed the appeal on the basis that it lacked jurisdiction, which we won't get into. And they filed a second motion to dismiss. The circuit court denied the motion again. Basically, what the Hawaii Supreme Court does this is weird. They basically say, I'm reading the synopsis now. 1, re-prosecution on a charge of second-degree murder was barred by double jeopardy. 2, EMED is not a chargeable offense, nor is it a lesser included offense, but a special defense to murder. Re-prosecution for EMED murder was not possible. And 3, prosecution for reckless manslaughter as a lesser included offense was not barred. And what they ultimately did was remanded it for reckless manslaughter.
Wow.
Yeah.
That's very applicable. And you're welcome to court. Should I file a declaration? Excuse me, Judge. I would like to bring up my podcast as evidence with Mr. Ben Lowenthal. We found something.
Right.
Wow. That's crazy.
So let me talk about double jeopardy. The Hawaii Supreme Court about 30 years ago had a very similar problem and addressed this issue about EMED and what happens on remand. And the case is pretty clear that the murder charge in that case 30 years ago was barred by double jeopardy, meaning they couldn't bring it back because the jury had come back with EMED. But then they do something a little difficult to deal with now, but what they also said was that EMED is not an included offense, nor is it a chargeable offense. It is the result of a special defense to murder. And so they don't really say you can have a retrial just to determine EMED. What they did in that case was that they allowed the government to put on a new trial for the included offense of reckless manslaughter. And so in that case, the defendant faced a second trial, but not life imprisonment. So if Dr. Konig prevails on appeal, the remedy and double jeopardy is going to be a hot issue. Does it go back down for reckless manslaughter? Is that what the new trial would be limited to? This case seems to suggest that that's the answer. But
Then there's the wrinkle of it being attempted murder in the second degree and attempted manslaughter due to EMED, and the contradiction of not being able to have reckless and intention in the same charge.
correct.
We're going around in circles.
Correct. And so it's, how do you attempt to do something that you don't have the intent to do? Those are the very questions that I am confident Dr. Konig's appellate team is going to be wrestling with.
Wow, it's so complicated, man. Because I've looked at this for hours and hours and hours. It's all in the argumentation. I feel like it's like a free ball. It's up for grabs. It's who makes the best argument, because because that's complicated and I'd want to move on. Is it possible, when it comes to Mr. Otake's third argument, which is the strongest, that because there is communication between the person on the live stream, well, allegedly, maybe there is, communication between a juror and the person on the chat, could he call the jury back and straight up ask on the record if it's true?
So that's tricky. I also want to comment, and this is just the lawyer in me, is that I haven't read the motion for new trial. I don't know which argument is the strongest. You
Okay.
mentioned but just getting onto the discussion about juror misconduct. You have the trial court's duty to look at the totality of the circumstances to determine whether the misconduct, assuming it is misconduct, whether the misconduct is so prejudicial that it impacted the jury's ability to be impartial. What I've just recited to you is the legal standard. You also have to contend with rules of evidence. The rules of evidence dictate what is and is not admissible and is subject to judicial review in applying that standard. Can they call back the jury and conduct the investigation? Yes, it's been known to happen that you can call back jurors. It happens a lot in civil cases too.
It is my opinion that the third argument was the strongest, and I wrote about it in my newsletter, so
Okay.
y'all could review it and you'll see exactly. I have screenshots of everything. One argument in the beginning was the interviews, which are not admissible. I just want to be like super upfront because all the attorneys have been like, yeah, Nick, by the way, interviews after a verdict are not like admissible to like make counter arguments to invalidate the verdict. So we already know that. But because there was a written declaration from the foreperson specifically saying that the jury was not unanimous on intent and not unanimous on attempted murder in the second degree, does the fact that it's not just an interview, but it's actually a declaration, is there some sort of wiggle room on reintroduction, or is it just, hey, Nick, what are you talking about? You can't just relitigate a verdict like that, even with a declaration.
I'm very, very reluctant to comment on that.
We've had a nice lengthy conversation. Anything you want to get off your chest, which I think is going to be my last question for every podcast, just let the floor be yours.
The First Circuit building has a lot of jury trials. When I started seeing jury trials in the First Circuit coming from other places, because I did not cut my teeth in the First Circuit in Honolulu, I was really surprised to see jurors who had been sworn and in the middle of the jury trial milling about the hallway. In other places, once the jury's in, you don't see them hanging around the building. And so I always felt, and I still feel, that there needs to be a way in Honolulu for those jurors to somehow be removed from the public during breaks, during lunch hours, during recesses. To have them just hanging out is a recipe for disaster, frankly. I mean, they see the defendant, they see the prosecutor, they see police officers in other cases, they see the media hanging around. I mean, it's my understanding, and I don't know how true it is, and you know better than I do because you go to the building a lot more. Jurors kind of just sit around waiting for court to begin right alongside defense counsel, right alongside prosecutors. And, that doesn't happen in other places. And so it's only a matter of time before a defense counsel makes that objection. And in my opinion, it should happen soon.
Spoken like a true future Chief Justice. Anyway,
Stop.
Thank you very much for your time. This has been a great conversation. When that next memo of opposition comes up, or if anything, people want to comment, I'd be happy to have Ben on again. I'll keep bothering him and I'll start, getting him on more often. Thank you very much for your time.
Thank you.